Good morning to you and welcome to session 7 of our free law revision. We hope to do just a couple of sessions on constitutional law and then we'll quickly switch to Ghana legal system and then law of contract and other areas of the law. So this morning we are going to discuss an issue related to a question which came last year. So the discussion is, not necessarily the same, but very much similar to that question. So we want to look at judicial review of legislative action. We have been discussing judicial review in constitutional law, but let me point out that when we talk about judicial review, it should be understood in two senses. So we have judicial review in the sense of what Article 2 and Article 130 of the Constitution actually envisage. That is where you go to the Supreme Court and invite the court to look at either a legislation, executive action, or anything which is supposed to have been done according to the Constitution, which have not been done, or things which have been done and are in contravention of the Constitution. And then you invite the Supreme Court to make a pronouncement to that effect, to pronounce on the constitutionality or otherwise. So that is one sense of judicial review. And then we also have judicial review, which is used in the sense of, if you like, administrative law, so to speak. Or the other way, that is to say that in terms of Article 23, administrative justice, that also like a judicial review. So where you are saying, and that is where issues of things we know from Winsbury principles, that's the Winsbury case, where we are told that where a person clothed with power has made a decision, and that decision is, for example, so unreasonable, so it's so repugnant to rationality, as emphasized in the case of the Council for Civil Service Union and so on, that no proper public official or entity applying his or its mind to what had to be decided will have come to such a decision, meaning that the decision is so irrational, the decision defies logic, reasonableness. Then the court will intervene and extend the prerogative rate of what? The prerogative rate or orders such as certiorari, mandamus, no quo warranto, and so on. And of course, that is also applicable in the context of supervisory jurisdiction over the courts below the Supreme Court. So that is another thing that we have to note. So, for example, where it is said that a particular court has, for example, let's say that breached rules of natural justice or has made an error, which is patent, which is quite clear on the face of the record, then the Supreme Court, or if it is below the High Court, court below the High Court, then the High Court will intervene to exercise supervisory jurisdiction and also by deploying the prerogative rates, mandamus, certiorari, prohibition, quo warranto, and so on. So you will notice that judicial review as a concept, from what I have said, have even been deployed in about, if you like, 3 or 4 senses. And that is why the question, and let me also add that, so if you compare our constitutional system, right, of Ghana with, let's say, that of the UK, they don't have what we have in terms of Article 2 and Article 130, that we can go to Supreme Court and seek, a declaration that something is constitutional or unconstitutional. Now, if you take the United States, as you know from the case of Marbury and Madison, the landmark case which through which Chief Justice Marshall very creatively read into the U.S. Constitution that which was not explicitly there, And what did he read into that? He read into the U.S. Constitution that by reason of having a written constitution and the constitution actually allocating functions and powers to the various arms of government and entities, that presupposes that it is the responsibility of a certain entity within the constitutional architecture or framework to make pronouncement as to whether an arm of government has carried out what is expected of it or not, or has defied the Constitution. And that has to be done by the judiciary. And that is why the US Supreme Court is able to assert the power of judicial review to make pronouncement of constitutionality or otherwise of other organs or organs of government. But we in Ghana, as we know, we have it expressly in our constitution. And of course, remember the Ray Akoto case, where the Supreme Court said that, well, they were bereft of the power to actually do that. So from 1969, 79, 92 coming, we have learned our lessons and we have it expressly in our constitution, as we know from Article 1 Clause 2, talking about the supremacy of the constitution, Article 2, giving local standing to every Ghanaian, be it a natural person or artificial person, to invoke the jurisdiction of the Supreme Court under Article 130 for the Supreme Court to make a pronouncement as whether something is constitutional or unconstitutional. So that is the sense which we are talking about. And that is why, last year or so, the question said that with the aid of relevant authorities, examine the ambit of the Supreme Court's power of judicial review of legislative action. So that was quite very specific. So in terms of what you'll be thinking of in responding to a question like that, or when you're invited to discuss or to examine the scope, the ambit, the parameters of the power of judicial review of legislation of the Supreme Court, you must note that first, Ghana's constitution is based upon constitutional supremacy, or the doctrine of constitutional supremacy, meaning that the constitution is supreme and no organ of government or nobody in Ghana is above the constitution. And of course, Article 1, Clause 2, we know that, and it's quite emphatic that where there is any such inconsistency between law and the constitution, anything, that is to be declared null and void to the extent of the inconsistency. So there's no dispute about that. So that point must be made forcefully. And of course, the fact that Article 2 enables you to go to court and say declaration to that effect. And as we have noted, the judicial review is a mechanism by which the Supreme Court enforces the supremacy of the Constitution. And a lot of areas. So, for example, Chief Justice Redu in the Aban case, that is the case between Ghana Bar Association and Attorney General when they sought to challenge the appointment of Chief Justice Abang, among other things. Redu, writing for the court, will make the point that the Constitution has eliminated the sovereignty of Parliament or the executive and subordinated all institutions of state to the Constitution. So that is a very cryptic, that is a succinct way of putting the doctrine of supremacy of the Constitution, in the words or the dictum of Redu JSC, as he then was. So therefore, the Supreme Court stands as a guardian of constitutional supremacy, empowered to review legislative acts for conformity with the Constitution. So we've done this. We are just, keep, rehashing what we need with the hope that it will sink well into our mind. So we know the constitutional basis of judicial review, as we have explained. So if you wrote your answer, key points which we are, highlighting will have to be reflected in it. Otherwise, you not make a very good score. So your answer must reflect the following constitutional provision. And let me hasten to emphasize that where you have a question from constitutional law, it is necessary that the key, relevant provisions of the Constitution, as far as you can remember, right, should be stated as part of your answer. So that is very important. And that is why I have always told you to be familiar with the provisions of the Constitution, especially the common or the very topical areas. So you must cite Article 1, Clause 2, the supremacy clause. You must cite the enforcement and interpretation clause, Article 2. You must also cite Article 130. If you are unable to cite one sub paragraph A and just cite Article 130, I think the examiner will mark it for you. And we also have Article 11, Clause 7. Article 11, Clause 7, somebody is wondering, where is that coming from? Sources of law in Ghana. When it comes to subsidiary legislation or delegated legislation, as you know, they are supposed to be laid before Parliament, gazetted for 21 sitting days, of Parliament. Now, where they are made or they are inconsistent with the Constitution or even the enabling act, as the case may be, it may be declared void. So these provisions actually, establish the authority and the duty of or the mandate of the Supreme Court to scrutinize legislation to ensure that it's consistent with the letter and spirit of the Constitution. So, what is the scope then? What are the parameters? So, first, we need to appreciate that the Supreme Court's supervisory jurisdiction over legislation, or the power of judicial review over legislation, is broad and covers both substance and procedure, as it were. So in terms of substantive inconsistency, all the things that we know about, substantive constitutionalism would apply. For example, where a matter is taken up to the Supreme Court regarding a particular legislation being inconsistent with the Constitution, the Supreme Court will have to find out whether the content, whatever is legislated in terms of substance, does it undermine the letter and the spirit of the Constitution? And in this respect, the entire Constitution is relevant, and also even the directive principles of order of state policy. As we know from the Lotto case, That is the National Association of Lotteries against the Ghana Lotteries Operators Association against the National Lotteries Authority, the famously known as the Lotto case, where the court has made it clear that the directive principles are justiciable insofar as we have like the corresponding provisions in other parts of the Constitution, as it were. But then, so in terms of substance, like the Parliament has the power to make laws, we have seen under Article 93 and all that. But the power to make law should not result in making a legislation or a law which violates the provisions of the Constitution or the letter and the spirit of the Constitution. So that is the substantive inconsistency we are talking about. And there are a lot of them. So, for example, if we take even the NPP Attorney General, we highlight the holidays legislation, and other policies which are made under it, which, among other things, enabled the Rawlins-led revolution to be celebrated as the 31st December with the state resources and other things. And the Supreme Court said that no, if you look at the letter and spirit of the Constitution, we cannot have a legislation, we cannot have any policy or any government measure which celebrates overthrow of a constitutional government, a constitution which was in force. We cannot celebrate that event with the taxpayers' money, and that was actually struck down. The national lotteries case, what you call the lotteries case, the Supreme Court, actually struck down the lotteries legislation passed of the to the extent that it sought to create, if you like, a monopoly, like trying to let only the National Lottery Authority, as it were, to be in charge of the lotto business apart from just the regulation. And that actually undermines, of course, people's freedom to work, freedom of association, and so many things. These are just indicative examples. You can get so many other examples. So all the cases which you have discussed previously and which you have been learning to, in which the Supreme Court has struck down a particular legislation in terms of its content being not in harmony with the Constitution, is also applicable. So let us keep that in mind. Then we also have procedure, like, we have procedural regularity as part of the judicial review of our legislation. The Supreme Court may strike down a legislation not because what the legislation is enacting, the content of it, is against the letter and spirit of the Constitution, substantively speaking, no. But it may well be that it did not follow the constitutionally prescribed procedure. So two things, there may be nothing wrong with what the substance of that legislation is, but there may be everything wrong, constitutionally speaking, in terms of procedure, how that legislation was made. And you have seen it a lot. For example, yes, Parliament has the power to make law and grant power to make delegated legislation. But as you saw, when it comes to legal education, there was a time that the General Legal Counsel, for example, was accused of trying to use either a subsidiary legislation to amend Act 32, which is the Legal Professions Act, and that cannot be done. You cannot use a delegated legislation to amend the parent legislation. That cannot be done, of course, except where, assuming maybe it's an aspect of the parent legislation, and in the body of the parent legislation is expressly such a power has been conferred. Otherwise, generally speaking, you cannot do that. And we saw that in the Asari case. And again, we also note that when it comes to even the electoral commission, remember the constitutional instrument which was not laid down for the prescribed number of days and how it was struck down as being unconstitutional. So here, it's not just the fact that the particular law, substantively speaking, undermine the constitution, but then the procedural nuances which the constitution says should be followed were not followed, and that is why it's struck down. So let us note that. And of course, recently, um, the Supreme Court has also, held that where a provision of the Constitution, I'm referring to the Citizenship, the Citizenship Act, which sought to exclude Ghanaians who hold dual nationality, right, from being eligible for certain position, like being a Supreme Court judge or some other senior positions of government. If you look at Constitution, the Constitution has provided lists of positions which cannot be held by those who hold dual citizenship. Now, Parliament in the Citizenship Act sought to add to that list, and the Supreme Court took the view that much as Parliament has the power to do to add to the list, that provision is a provision which must be amended according to how the Constitution is amended. So you have to come within the relevant provision as whether it is entrenched or not entrenched. And if it's you are going to amend a constitutional provision, it must be properly done, and that must be intentional. You don't just do it through the back door without letting us know that it's a constitutional provision that we are seeking to amend, and following the proper procedure as whether it is entrenched or not entrenched in terms of Article 289, Article 290, and Article 291, as we have seen previously. So here, you see the challenge is like the procedure. The procedure. And then, of course, in the same vein, Article 106, Article 107, 108 provides a procedure, much as to form as Attorney General, we are told that the court will not extend its writ into the Chamber of Parliament to find out what is done there. But the court, if given the evidence as to whether a procedure was not followed before a particular legislation was made, especially constitutional procedure, then the court would intervene. Of course, we also have the entrenched provision, as I have indicated, and they are given a higher protection, and you cannot amend or tie it through the ordinary legislative means. You must use the prescribed procedure. So where you don't do that, the court can actually come in to strike it down. We've discussed delegated legislation already. Again, when it comes to judicial review of over legislation, it is also worth noting that if you look at Chapter 5 of the Constitution, that on the fundamental human rights and freedoms, there is an obligation on various state institutions, including Parliament, to uphold the fundamental freedoms and human rights enshrined in that chapter. And here we have to remember that yes, the High Court has been given exclusive jurisdiction original jurisdiction concerning enforcement of the human rights in terms of Article 33, okay? But where the Supreme Court, where there is a parliament has actually made a law, and that law, for example, undermines fundamental human rights and freedoms. In that respect, it's not just a matter of human rights enforcement, it becomes a constitutional matter. And Supreme Court to intervene to exercise its power of judicial review over legislative action, over legislation. So that is where, so here when the Supreme Court comes in, the Supreme Court is not just coming to enforce anybody's human right in that sense. No, the Supreme Court is coming in to say that this particular legislation did not, in substance, for example, uphold fundamental human rights and freedoms which have been guaranteed by the Constitution. And for that matter, we are striking it down. So it's different from saying that my rights have been violated. And that one, you have to go to the High Court and do that. So as you can see, like the closer case, civil service and local government institution against the Attorney General. So here, the emphasis is not so much on a particular person saying that his rights have been violated, but by certain legislative measures. You are saying that the human rights which have been guaranteed have actually been not risks being violated if the legislation is not struck down, and that will be done. We have already discussed as per Appiagyei-Atua, and I said that the principles which have been laid down, which guide judicial review in terms of when will the court actually come in to say that there is a proper constitutional case for the Supreme Court to intervene. You have to bring yourself within the text. We've discussed that in the previous sessions. Another session 5 or 6. Yeah, so please go back to it if you have forgotten. Yes, the Supreme Court, in doing the judicial review over legislation, is mindful of the need to respect what we call separation of powers by not, if you like, micromanaging other arms of government where it is not germane to the issues of constitutionality. So, for example, there's a case that is this is children's, and then there's a case that I want to discuss. This is a children's case. Professor Mensah, Child Rights International against Attorney General, right? Interesting case where the Child Rights International went to court and invited the court to say that by combined effect of provision of the Constitution of certain aspects of human rights, the government is breaching the Constitution by allowing street children to be on the street and begging and not taken care of. So the court should make a declaration to that effect. And then the court actually disagreed. And if you remember that case, the court was taking the view that you cannot just come to court and say in general terms that the Constitution has been breached without showing specificity. You cannot just make general claims of violation. There must be specific claims of violation. Otherwise, you turn the power of judicial review of legislation into some kind of like a fishing expedition. But that is not, the Supreme Court is not there to do just academic exercise. There must be a concrete case. And that is why anytime there's a constitutional case, the threshold issue, or the preliminary issue, which will have to be satisfied, is that whether the jurisdiction of the Supreme Court has properly been invoked. In other words, is there a constitutional case properly so called, as we have seen? Is there a case of interpretation? Is there a case of enforcement, or what? So you cannot just speak in general terms, just come to Supreme Court and say that because the Constitution has provided that everyone has the right to a decent living, everyone has this, the directive principle of state policy has provided for this, and for that matter, if you have people sleeping outside, then the Constitution will be violated. No, that is not how it works. So let's look at the case of the Child Rights International against the Attorney General, which was decided not too long ago. Yeah, so we cannot overemphasize the significance and importance of judicial review. And of course, your answer will have also canvassed that as part of the points that you need to raise. And the utility of judicial review includes the fact that it preserves constitutional supremacy by restraining parliament. That is very important. Ensure checks and balances and prevent legislative overreach. We have said already that we don't have parliamentary sovereignty or supremacy as pertains in maybe countries like the UK. Of course, it also upholds the rule of law and democracy by protecting citizens' rights, as we have seen. So, Justice Redu's dictum, which was made the focus of the question, could be said to reflect the reality that we have just been discussing, that Parliament, like all other arms of government, is subject to the Constitution. I mean, that is the crux of the matter. Parliament is subject to the Constitution, and if Parliament is subject to the Constitution, how is Parliament actually police, quote and unquote, right? Or how is Parliament, monitored, or who exercise oversight over Parliament in terms of its adherence to the tenets of the Constitution? Okay, so you have to provide conclusion in your answer. And anytime you have, as I've told you, the marking schemes will always allot some marks, either one or two or whatever marks. So make effort in every answer to provide some conclusion by pulling together the key argument you have made and your final reflection in direct response to the heart of the question. So that's the point about the conclusion. So for example, we could have concluded that the Supreme Court's power of judicial review of legislative action is exclusive, wide, and essential under the 1998 Constitution. It extends to substantive compliance, procedural regularity, fundamental rights, entrenched provisions, and delegated legislation. And this power is indispensable for safeguarding constitutionalism and rule of law in Ghana. So this is like a conclusion. You pull everything together. You have reflected on the heart or the key aspect of the question. Good. So I would like to review some cases with you before we end this particular session. Remember the case of Richard Sky against Parliament of Ghana and the Attorney General, decided not too long ago, at in December, just before the election, and it's in relation to the Human Sexual Rights and Ghanaian Family Values Bill, if you remember, which was passed by Parliament last year, that's 28th February 2024. And as you recall, the Human Sexual Rights and Family Values Bill was a private members bill, meaning that it was not introduced or sponsored by the government. Let me put my power on before it will go off. Just a second. Uh, okay, sorry for the break. There's power now. Good. Yeah, so the Richard Sky case was talking about the Human Sexual Rights Bill, which was private member in the sense that it was not introduced by by the government. It's just a member of parliament who sponsored it. Now, as we know, the bill sought to make same-sex relations, criminal and other related activities. The case was, filed earlier on, and Richard Scar preemptively in the sense that it was a bill, it was not an act. So preemptively challenged the bill's constitutionality in the Supreme Court under Articles 2, 1, and 131, as we'll be talking about. And he sought a declaration that the Human Sexual Rights and Ghanaian Family Values Bill violated fundamental human rights. So he recited so many provisions, Article 12, 15, 17, 18, 21, and 33 and 5. And he argued that the bill was wrongly admitted. In other words, Parliament made an error when it permitted the bill to be accepted in taking through the legislative process. Now, in his view, that was a violation of Article 108 of the Constitution. Article 108 of the Constitution, as you remember, says that no bill shall be introduced which has the effect of imposing a burden on Ghana's purse, the national purse, either by expecting government to spend state money in the implementation of the law or by imposing some taxes on the citizen. If you have a bill like that, it's only the elected government of the day which can sponsor it and not any other entity. So Richard Sky was saying that this bill, in his view, was in a way going to impose financial burden in some respect on the state, and that should not have been introduced by a private member, but should have been introduced by the government of the day. And as we know, it wasn't introduced by government, it was introduced by Mr. George, the Honorable Minister, I mean, Mr. Sam George, now Honorable Minister for, I think, the communication, yes. And then he also argued that the parliament did not have the requisite quorum when it passed the bill. And for that matter, it wanted the Supreme Court to grant injunction, to restrain the Speaker of Parliament and the Clerk of Parliament from presenting the bill to the President, and also to enjoin the President from assenting to the bill. As we know, under Article 108, after a bill has been passed, Parliament will have, the President will have to, give the presidential assent to it, the signature to it, before it will become a law, as it were. So he wanted that not to happen because of the problems that he had put up. Yeah, so in response to the case of the plaintiff, Parliament, as it were, as the first defendant or like the Speaker, argued that the jurisdiction of the Supreme Court was not properly invoked. And why was this so? In his view, the plaintiff had not raised genuine interpretative issue. And as you know, the ex parte accusa, which have been given blessing by a plethora of authorities we discussed, to invoke the original jurisdiction of the Supreme Court with respect to interpretation or enforcement of the Constitution, you must raise proper issue. Otherwise, you've not engaged that jurisdiction of the court. It also, Parliament also took the view that if you look at the things he's complaining of, there are matters which fall within human rights enforcement, and for that matter, the proper forum should be like the High Court. And Article 33 clause 3, as well as what the Supreme Court said in Edusei versus Attorney General. And he also, Parliament also argued that no evidence showed the bill imposed a financial charge or that quorum was absent. Attorney General, who was also the second or the co-defendant, of course, by reason of Article 88, every constitutional matter, the Attorney General will have to also be made a party. So the Attorney General agreed with all the arguments by the Speaker. So the issues, as we can see from the arguments that they have made, whether the Supreme Court jurisdiction had properly been invoked. In other words, this case, does it raise interpretative issue? Are there rival meanings being canvassed by the parties? Or this case saying that a particular provision of the Constitution is ambiguous, or the effect of the application or the scope of it is unclear? So these are what we call the interpretative issue. And we needed to, the court needed to find out whether the plaintiff had actually met that requirement. Then the court also needed to find out whether the bill as passed, although it's not a full act, full legislation yet, violated the provisions on the human rights, and whether Parliament complied with Article 108 in admitting a private member's bill with financial implication. Then the other issue was also whether Parliament had appropriate quorum or Parliament was quorate when passing the bill. So if you look at the decision, the substance of it is that the court dismissed the action, and the court took the view that the original jurisdiction of the Supreme Court, okay, in terms of Article 2, Clause 1 and Article 130, Clause 1, applies only to enactments. In other words, it applies to acts of Parliament and not bills. A bill, if you look at the Interpretation Act and also the Standing Orders of Parliament, a bill, and also if you look at even the Article 106 itself, a bill in substance is a draft or proposed law. So if it's a draft or proposed law, what it means is that it can change. So how can you, as a Parliament, Supreme Court, to make a declaration of something which does not have the necessary finality. And in fact, it still did not make any difference that the bill had been passed by parliamentary right pending signature of the president, because as we know under Article 106, the president can exercise a veto and tell the Council of State that he thinks that due to XYZ or due to this and that, he doesn't think that this bill should be signed into law, or may even recommend that maybe certain things should be done. And then Parliament may be forced to either go and look at what the president has said, unless they can get the requisite majority to override the presidential veto. So as you see, so there's that clear possibility of some changes still going on. So how could you expect Supreme Court to exercise original jurisdiction of making pronouncement of constitutionality or otherwise in respect of something which was still evolving? So the challenge, in a sense, was premature, as there was no enforceable enactment. So if you look at the judgment, Professor Mensah Bonsu, for example, stated, which I quote, "The invocation of the interpretative jurisdiction is based upon an enactment or any act done under the authority of an enactment. In the instant case, there is not as yet an enactment properly so called, since the legislative process which will transform a bill into an act with the force of law has not yet terminated." This is a very a clear statement of the rationale supporting the holding of the Supreme Court. Again, Justice Agyei-Atua also, in his concurring opinion, will say that a bill is therefore a draft in the process of becoming an act of parliament. It is yet to crystallize into law. It is inchoate because it has not become law. It has no legal consequence, as you have explained. So you cannot actually go to, and so let's get this clear. The supremacy, doctrine, and then the power of the Supreme Court of enforcement, and Article 2, Article 130, does not actually apply to bills, does not apply to things which are yet to become law. So let's keep that in mind. And then Professor Mensah Bonsu again will say that the plaintiff has short-circuited the process of legislation and not permitted the enactment to be born. Much harm could be done by a hasty anticipation of its possible effects, which could prove to be largely speculative. So if the Supreme Court, for example, were to actually proceed to examine constitutionality of the actual content of the bill, which has been passed, Justice Professor Mensah Bonsu was saying that that would be plunging the Supreme Court into an exercise which is largely speculative, since no things could be changing. Of course, with respect to the human rights argument, although it's orbital because of the most important holding that the whole matter was premature, but that should have been taken to the High Court, assuming it was even ripe. So, as Justice Barbara Kayensu, in her contributing opinion, having alluded to some of the defendant case, will say, let me quote, "The second defendant holds a view that since plaintiff's reliefs amount to the enforcement of human rights, the High Court is the proper forum to resort to, as provided by Article 33, Clause 3 of the Constitution of Ghana." And then he cited Bimpombita against General Legal Council. Then she will continue, and this is the most important one. "Glaringly, this is a confused relief. There is nothing to interpret regarding those referred to human rights provision. Those provisions are clear and unambiguous, and the mere references to them do not trigger any genuine issue of constitutional interpretation." Good. So a takeaway from this particular dictum is that the mere fact that you have recited constitutional provisions, right, in the framing of your case does not automatically render your case a constitutional case for which the Supreme Court should exercise its jurisdiction. You must go a step further. You must demonstrate in the specific ways in which the so no, I mean the provision that you have stated as the impugned provision, specific ways in which they have been violated. Then, with respect to Article 108, there was an issue as whether Parliament erred by not complying with Article 108. Article 108 said that Parliament must not allow a bill going to impose financial obligation on the state to be introduced except by the government. So, with respect to that, the substance of the holding was that the court maintained the point that yes, the speaker would probably be criticized for not exercising his jurisdiction properly under Article 108, but that was not necessary at that point because the court did not want to intrude into the parliament's lawmaking processes at the bill stage. So, mind you, we talk about earlier when we were discussing the question that the court, in exercising judicial review over legislation, will also look at procedural aspects as whether Parliament followed the proper procedure. Now, that will only become relevant where the final product has been signed off. That is a bill, the past bill has been signed into an act. And then, if somebody is trying to challenge that act should be struck down because it didn't follow a particular procedure, it is at that stage that the Supreme Court become interested in looking into the merits of such complaints. But where it is still a bill, it's just premature. And the Supreme Court will not be concerned about whether procedures have been followed or not. So let us keep that in mind. And that is why Justice Apiagyei-Atua will again say that what plaintiff's action implies is that the first defendant and our Parliament of the Republic failed to adhere to the dictates of Article 108. However, our interest should only be to a satisfaction of the constitutional obligations on the legislature and not how the legislature goes about that exercise, simply because the legislature is a master of its own procedures. And this principle is well known. The Parliament is the master of its own procedure. And that is why in 24 versus Attorney General, if you remember, the Supreme Court will say that the court will not actually extend its writs into Parliament to micromanage the processes of Parliament. And J.H. Mensah versus Attorney General, the same point was made. If you remember, J.H. Mensah versus Attorney General, after the first government of the Fourth Republic, that is from 1993 to 96. Yes, so the first 4 years, so to speak, some ministers were retained by then President Rawlings. And as you know, the Constitution requires that, Article 78, that the ministers will have to be appointed with the prior approval of Parliament. And there was this issue as to whether the retained ministers or the holdover ministers must they go through the same scrutiny in terms of deliberate vetting as those who have freshly been nominated ministers? Parliament, decided to use its own procedure in terms of being very, abridged about that. But Mr. J.H. Mensah went to court and sought to challenge that. And the Supreme Court emphasized the fact that, yes, Supreme Court will not actually, they didn't use the word micromanage, but in substance, trying to say the Supreme Court will not, interfere in how Parliament conducts its business, so long as it stays within the remit of the Constitution. The Constitution says that there should be prior approval, right? The prior approval, Parliament will decide if it's going to do vetting, if it's going to do general voting or whatever. It's not for the court to dictate to Parliament how the approval process will be done. What the court needs to satisfy itself is that has approval be done. And that is why in the Richard Sky case, Justice Jeffrey Mpon Wage said that, quote, any attempt on our part to strike down the bill will amount to striking at an unborn baby. I'm inclined to the position that the rightful state to invoke jurisdiction of this court is when the bill has become a full-blown enactment in terms of Article 2.1. Okay, the quorum issue was dismissed because the court took the view that the plaintiff had not provided credible evidence before the court as to whether the quorum had been met or not. But in my view, that point was even not necessary, because once you take the first holding that the whole action was premature, if it's premature, then all the other issues raised are actually inconsequential because it's premature. So you don't need to deal with any of the complaints regarding that particular bill. So we'll not even bother to look at that. So the point to note is that the Richard Sky against the Parliament and Attorney General provided a strong confirmation that judicial review of legislation in Ghana applies only when a bill has become a law, that is after presidential assent and not before. So let's keep that in mind. And again, we also have, in a sense, a reaffirmation of the doctrine of separation of powers, because the Supreme Court or the Judicial cannot preempt or interfere in parliamentary processes. Of course, the point one that the human rights challenge should go to the High Court is a point which is well known, so we will not belabor it. And if there are any concerns of procedural impropriety, like irregularities, like quorum not being met, or the requirement under Article 108 that only the government can introduce a bill which has financial implication, not being satisfied, those matters can be looked into when the bill has been passed and signed, before we can entertain those such of complaints. Yeah, so let's keep that in mind. And then another case I would like us to discuss is the case of Kojo Appiagyei against Attorney General, a case which we all know very well, so we will not belabor it. As you remember, relates to a challenge to imposition of the Restorations Act, Act 20, Act 1012, which was passed in 2020. And as you remember, this was a reaction to the public health crisis, the COVID-19 pandemic, which we had. And the president, exercising his power under this Imposition of Restrictions Act 2020, Act 1012, issued various EIs or executive instruments which sought to restrict movement and freedom of assembly and other rights. As you know very well, we all know this, we are just reminding ourselves. Now, Professor Appiagyei-Atua of University of Ghana School of Law went to the Supreme Court and challenged constitutionality of this Act 1012, that's the Imposition of Restrictions Act, and marshaled the argument that the Act empowered the president to unilaterally suspend fundamental rights in a manner which bypass or which sidestep the constitutional framework under Article 31 and 32 govern public emergencies. Now, if you look at Chapter 5 of the Constitution, particularly Article 31 and 32, you notice that the elaborate framework regarding how human rights should be managed in times of emergency, in terms of national crisis, in terms of what they call state of emergency. How do we manage human rights in a way which will not bring about unwarranted or unnecessary infringement on human rights? So human rights are so sacred or sacrosanct in the sense that the Constitution would like human rights to be respected at all times, but then where circumstances are such that for greater national interests, national safety, public health, and so on, if we need to circumscribe human rights, it should be done in a manner which is no more than necessary to achieve the stated objective. So we use what we call the minimalist principle. Whatever interferences we are going to do should be the most, if you like, minimal interference needed to achieve the stated objective and no more. And then there should also be transparency and there should be accountability in the process. And that is why if we look at the framework in Article 31 and 32, you notice that president is supposed to be held strictly accountable when he decides to impose any interferences in the name of a state of emergency in the sense that I've explained. So that we don't undermine human rights lightly. So Professor Appiagyei was saying that if you look at how the Imposition of Restrictions Act have been framed, it gave unilateral power to the president to suspend fundamental human rights in a manner which defies the safeguards provided under the Constitution, particularly Article 31 and 32. And again, he also argued that if you look at the preamble or the Act 1012, trying to say that it's relying on Article 21 clause 4. Now, Article 21 clause 4 provides that human rights may be limited for public safety, public health, and so on and so forth. Now, he was of the view that reliance placed on that limitation clause was wrong because it applied to normal times. That is, in situations where life is normal, we have normals, we don't have any state of what? Emergency. and that it is not a derogation clause. So derogation clause applies for emergencies. And he also had a concern that if we look at the extent of powers given the president to make EI to impose restrictions, it's effectively sidelined Parliament and the courts regarding oversight rules. Because if you look at Article 31 and 32, where the president make a proclamation of state of emergency, if you look at those provisions, he's supposed to report to Parliament, and all those processes can be challenged, even like in the court, as it were. But in his view, if you look at the Act 1012, it seemed to have given dictatorial powers to the executive. But the Attorney General disagreed with Professor Appiagyei and argued the a contrario, or the opposite of all the arguments which the plaintiff had actually canvassed. So the important issue which had to be discussed is that whether the plaintiff had and you notice that if you read the cases, if you are to read the case and you have your brief, notice that in all constitutional cases, this first issue will always come up, whether the plaintiff had properly invoked the Supreme Court's original authorization, and Article 2.1 and 131. So the things that we talk about in the ex parte accusa case or Sebonsu case and all those things become still relevant. And then two, whether the Imposition of Restrictions Act 2020, Act 1012 was consistent with Articles 21, 31, 32, 58, 93 to 125.3 of the 1992 Constitution. So these were the issues. Justice Amegache wrote the judgment of the court, and we have summarized his erudite opinion here on point by point. With respect to jurisdiction, the court held that, yes, the writ had properly invoked the jurisdiction of the court. And part of the opinion of Dazamegacha reads as follows, quote, consequently, as this court possesses interpretive and enforcement jurisdiction under Articles 2.1 and 130, no necessity arises. Accordingly, we overruled the preliminary objection. So the court agreed that if you look at the issue, they were properly invoking the jurisdiction of the court, so we no waste time on that. Now, there was another argument as to whether it was right for the law, the Imposition of Restrictions Act, to cite Article 21, Clause 4. Mind you, Article 21, Clause 4 is a general limitation clause which provides justification for interference of human rights under those stated conditions, public safety, public health, and so on. Now, the court took the view that Article 21, Clause 4, yes, authorizes continual limitations, that is, derogations during emergencies are governed by 31 and 32. But the imposition of restoration has sought to blur this line. In other words, it sought to appreciate the fact that we have two regimes. We have a regime for interfering justifiably with human rights in normal times, that is, in absence of state of emergency, and interfering with human rights with justification in emergency situations. So the court of the view that the legislation sought to mix that distinction. So this is how Justice Amegache put it. We've quoted portions of his dissent. Derogations are often temporary and may suspend a right wholly. On the other hand, limitations are common to all rights, may be permanent, and are meant to perpetually balance the public interest with the rights of individuals and groups. So we say that Article 21 Clause 4 was not intended to be applied to restrict fundamental human rights during public emergencies. The absence of the phrase public emergency indicates that the provision is a means of limitation and not derogation. So, in a very erudite way, the Supreme Court, through the mouth of Appiagyei-Atua, was saying that if you examine Article 21, Clause 4, the various things stated as being the basis for limiting human rights. To start with, we don't see the word public emergency as being one of those. And again, for the matter stated and the limitation which may be provided, they could practically be of a permanent nature. On the other hand, if you look at Article 31 and 32, situation, it's derogation or some temporal sidestepping, right? Some temporal sidestepping or deprivation of human rights and is not supposed to be permanent. And if you look at it, even when it comes to, for example, even curfew and so on, you don't impose it more than, let's say, 30 days, as it were. Short intervals. So all the measures which may be taken during state of emergency within the period of Article 31 and 32 are supposed to be of a temporal nature or effect. And if that is so, then it would be wrong for you to place a reliance on Article 21, Clause 4, when you have a legislation like Imposition of Restoration Act, which is supposed to be a state of emergency legal intervention. So that was the point the court was making for us. Then, in terms of the constitutionality of the Imposition of Restoration Act itself, the court held that it was unconstitutional because it vested emergency style power solely in the executive, bypassing parliaments and the courts. So in the court's view, if you look at Article 31 and 32, when it comes to emergency situation, matters which are meant to interfere with fundamental human rights and freedoms are done in a very calculated way through, mutual accountability and oversight involving all the triumphs of government. The executive is supposed to do it, but then the executive is supposed to report to parliament for parliament to approve, and then the court may even come in if someone wants to challenge the whole thing. But if we look at how the Imposition of Restoration Act had actually empowered the president, the court was of the view that parliament and the courts seem to have been excluded, and that was not what Article 31, Clause 2 actually envisaged. So the court was of the view that to that extent, it was unconstitutional and then null and void. Again, of course, we can also learn something from separation of powers. As please put your mic off. Yeah, so as we have argued, fundamental human rights are so precious that it must be upheld at all times, and if it has to be interfered with legitimately at all, then it must be done in a very calculated manner. And that is why it is wrong for Act 1012 to concentrate all the powers in the president. So let us keep that in mind. I think, let me look at the time if we should discuss one more case. Okay, so let's look at just one or two more cases to finish this, and then we go. Let's look at the Derek Edusei case. Okay, so another case, remind ourselves of, I know you are all experts now. You are leading constitutional lawyers, so you know the cases, but just to make sure that we are on the same page, let's remind ourselves. Another recent case by the Supreme Court, which is worth recalling, the case of Derek Edusei against Attorney General. And that case was simply about a challenge to some provisions of the Companies Act, particularly Section 13, 2HII, Section 172, Section 177. And these provisions of the Companies Act actually will lead to disqualification of persons from serving as directors of companies if they have been charged with certain criminal offenses or under investigation. And the background is what we know from Article 19, Clause 2C of our Constitution, that everyone or any person who is charged with any criminal offense or arrested is presumed to be innocent. So the presumption of innocence, that if you are charged with criminal offense, the Constitution considers you to be innocent until the state has, beyond reasonable doubt, marshal and adduce evidence to show that you are guilty. Now, if we look at the Companies Act, which is 2019, which repealed the 1963 Act, we had a similar provision in the 1963 Act, but those who made the 2019 legislation, I think they forgot it, because for many years we've been talking about this in company law class. So I'm surprised they will still retain this. And so thankfully, Mr. Derek Edusei took it up. And the Supreme Court, as you notice, agreed with him that it is constitutionally wrong where the Constitution has guaranteed presumption of innocence for a person charged with a crime, to at the same time have a legislation, the Companies Act, saying that if you have been charged with a crime or you are you are under investigation for certain types of crime, like fraud or dishonest nature, then you are not qualified to be appointed a director. You are not qualified to be appointed the director of a company. So the problem with this is that whether the provisions of Act 992, that's Companies Act, which actually say that if you have been charged with criminal offense involving fraud or dishonesty, then you don't qualify to be appointed a director or be like a subscriber of a company. Whether those provisions are inconsistent with presumption of innocence under Article 19. And of course, the same thing also apply to whether they're inconsistent with their right to fair hearing, and also the dignity of unconvicted persons under Article 15, clause 3. And then there's also this issue whether Parliament could lawfully buy persons charged or under investigation from company directorship without prior conviction. So these were the issues, and the Supreme Court held that the words charged with under the impugned provision, that is section 13, subsection 2, paragraph H, subparagraph I to II, and section 172, subsection 2, paragraph A, subparagraph I and II are unconstitutional. Unconstitutional in the sense that being charged with an offense is not equal to being convicted. If you are charged with an offense, it does not automatically mean that you'll be guilty. Now, you are convicted when you are pronounced guilty. So if you have not been pronounced guilty, why should we treat you as a convicted person and saddle you with legal disabilities which are faced by a convicted person? And the court reasoned further that by automatically disqualifying charged person will equate them with convicts. Because if you are convicted, then you suffer certain legal disabilities, isn't it? But where you are not convicted yet, and there's a high possibility that you could, like, you will not even be convicted. Why should you burden you legally like someone who has been convicted? And that is why Justice Barbara Kayensu will say that to punish an innocent person not convicted or pronounced culpable for the commission of an offense, either directly or indirectly, sins against the constitutional presumption of innocence. So ultimately, the court struck down the phrase charged with, and the provisions which disqualify convicted persons, those ones were left unaffected, because if you've been convicted, then you've had your presumption of innocence being rebutted, so you don't have to be given any special treatment. You have to suffer the legal consequences of being a guilty person. So those aspects were actually maintained, but the part which relates to the non-convicted, unconvicted person, those were struck down. Then the fair hearing argument, the court agreed that the impugned provisions of the Companies Act violated fair hearing by imposing automatic disqualification without judicial determination. Now, it's against natural justice. You cannot condemn a person without hearing him. The person is charged with the crime, is not be pronounced guilty yet, and we are not even told whether a submission of no case has been rejected and a prima facie case having been made. All that we are told is that you are charged with an offense, and that is too arbitrary. You haven't granted hearing to the person. So if you look at Section 177, subsection 1, paragraph C and E, with respect to maybe those who have had other bankruptcy, order made against them, or they have been, previously convicted, and they are being debarred from being directors or being disqualified. They can even go and challenge it regarding propriety of those suppositions, providing the basis for their disqualification. So that one, I mean, is fair. And for that matter, Justice Asiedu put it in a beautiful way that if you look at sections 13, subsection 2H and III, and then section 172 to AII, they give final judicial power to the legislature. And then whereas section 1771C gives effect to Article 125, 3 of the Constitution. So if you look at Article 125 clause 3 of the 1992 Constitution, it talks about the final judicial power. And the final judicial power is vested only in the Judiciary of Ghana, and no any other entity or arm of government can exercise final judicial power. So His Lordship Asiedu was trying to say that by saying that people charged with, offense involving fraud or dishonesty are automatically disqualified from being appointed a director. It's like you have arrogated the power of final judicial authority to Parliament because you haven't given them the opportunity to even challenge it. But if you look at the other context, even those who have been convicted or those who have had a bankruptcy order made against them, which has not been discharged, they can go to court and challenge it. And that one is right. Yeah, so if you look, as I indicated, if you look at the section 177 of the Act 992, you notice that there are some other qualifications, but they are not automatic. And that one is good. It requires a hearing of the both parties before the court would actually decide whether a person is disqualified or not. And that is why Justice Poorman GSC will say that so long as it is the court that is determining the criminal culpability of the person challenged, no provision of the Constitution is contravened. But where you do not provide such a mechanism, and all that to say is that if a person is charged with, a person is under investigation, such a person is disqualified from being appointed a director, then it becomes very easy. All that you do is to arrange for somebody to be arrested and let him be charged or let him be under investigation, and the person cannot be made a director. So ultimately, the court took the view that the word charge is unconstitutional, but other provision of Article 177, which did not impose automatic disqualification and allow even the court to intervene, that was consistent with the Constitution, and that was upheld. So let's keep that in mind. Now let's get the case of let's about the case of Amanda Odoi. Maybe one more case. The case of Dr. Amanda Odoi against the Speaker of Parliament and Attorney General, which is similar to the Richard Sky, which we discussed. So difference is not much. The facts are the same as the Richard Sky. The case against the backdrop of the LGBT bill, so to speak. And as you know, Parliament passed the bill 28 February 2024, and Dr. Amanda Odoi challenged constitutionality of the Speaker's conduct and Article 108. So similar to some of the arguments that have been canvassed in the Richard Sky case. In Article 108, and argued that the Speaker failed to render an explicit objective opinion on whether the bill imposed a charge on the consolidated fund or public funds. And then again, she also argued in the alternative that by allowing the bill to proceed, the Speaker had constructively given an opinion that was erroneous. In other words, trying to say that the Speaker, by presiding over parliamentary proceedings for this bill to be passed, indirectly, the Speaker seemed to have actually agreed that the bill was not going to impose any charge on the consolidated fund or the public funds, as it were. And then she also argued that if you look at the bill so passed, it was inevitably or definitely going to impose physical burdens, financial burdens on the state. In which ways, according to her, when it comes to law enforcement, of course, the police will be paid, the courts will be paid, prosecution, the prison costs, all those, in her view, are imposing financial burden on the state. And that is the reason why the Speaker should have ensured that the remit of Article 108 had actually been satisfied, that the bill should have been sponsored by the government and not by a private member. So those were the action, and she saw declaration of unconstitutionality, an injunction against further progression of the bill, and orders restraining the Speaker. So essentially, those were the things that she canvassed. So the issues very similar to some of the issues under Richard Sky. That is whether the Speaker of Parliament had a constitutional duty under Article 108 to render an explicit opinion on the bill's physical implication. The physical implication refers to whether it imposes financial burdens on the states. Then whether the Speaker's failure or implied opinion breached Article 108 and rendered the bill unconstitutional. Then whether judicial review jurisdiction under Article 2, Clause 1 and Article 130, Clause 1 could be exercised before presidential presidential assent. So this issue of this prematurity we saw in the Richard Sky case, whether Parliament exceeded its authority in passing the bill. So with respect to jurisdiction and the whole case being premature, the court made a holding that judicial review cannot be exercised over a bill, which is still in the lawmaking process, as we saw in the Richard Sky case. And then the point was reiterated, as Appiagyei-Atua had put it, that judicial bill is just a draft, in the process of becoming an act of parliament, and it is yet to crystallize into law. It is inchoate because it has not become law. It has no legal consequence. It is a blueprint, an abstract of a sort, as it were. So it was also treated in the same way as the other case. Then with respect to that 108 and the Speaker's duty, the Supreme Court rejected the argument that Article 108 required a physical impact assessment, a particular mode of expression. In other words, the court did not agree with the plaintiff that whenever there was a bill, the Speaker had to actually conduct assessment as to whether the bill is going to really require how much money to be spent, and is it coming from the taxpayers money, as in the contingency funds, consolidated funds, and other public funds. Now the court took the view that the constitution per paragraph per Article 108 did not really require any particular mode of doing this. it is sufficient that the Speaker, in his opinion, allowed the bill to proceed. So Justice Esiedu will put it that, quote, Article 108A does not prescribe the mode or manner in which the person presiding shall express his opinion. It is purely a matter for the discretion of the person presiding. Of course, the court said that the court took the view that the presumption of regularity, that is the omnia presumintu rite se acta, under the Evidence Act was applicable, and the plaintiff had actually failed to rebut that. Again, in terms of separation of powers, despite the fact that I have the hybrid form, it doesn't mean that separation of powers is thrown into the gutters completely. No. The court emphasized that striking down the bill's pre-enactment, that is before it is enacted, will amount to judicial intrusion in the legislative process. And that is why Justice Agyei-Atua put it this way. While we must jealously secure our power of judicial review, there must also be reasonable restraint. We run the risk of tying the hands of Parliament in the discharge of its vested lawmaking function. So this case can also be cited when we are discussing separation of powers. So ultimately, the case of the plaintiff was dismissed. So let's keep that in mind. Now, the last case we'll discuss for this session before we come back later in the afternoon. I may probably do about 3 or 4 more sessions today, depending upon how tired I am. The other case which I want us to also remind ourselves is the Child Rights International against Attorney General. We've alluded to it earlier on in the day. Very interesting case. You all know the NGO or the civil society organization called the CRI, Child Rights International. And it's known for advocating for children's welfare for quite some time. So this organization invoked Article 2 and 130. Mind you, Article 2 says a person, and a person has been interpreted to refer to both a natural person and a juristic person. And that is why Child Rights International is not the natural person, it's a juristic person, artificial legal person. But it is permitted to invoke Article 2 and 130. So it sought declaration that conditions of children living on the street violate various constitutional provisions. Article 28, like what's on the rights of children. Article 13, Clause 1, that is the right to life. Article 15, Clause 1 and 2, on human dignity. Article 35, Clause 4 and 5, directive principle of state policy. So the plaintiff was saying that if you look at how children are living on the street, all these constitutional rights have been violated. And for that matter, the plaintiff sought a declaration that the government was in breach of children's rights and sought orders for child protection units and penalties for child exploitation, free healthcare, enforcement of educational rights, and reporting obligations to the court. So these were, in effect, some of the things canvassed. In terms of the plaintiff case, the factual background, he claimed that we have 61,000 street children who suffer denial of education, healthcare, safe shelter, and dignity. And that if we look at the Children's Act at 560, we have government institutions which have been mandated to perform their duties for the good of these children, but they are not. So the plaintiff rely on so many foreign cases, including the Ogateles against Bombay. That's an Indian jurisprudence. Ogateles against the Bombay Municipal Corporation. Appiagyei-Atua against the Paraguay. That's the Latin America. And our own local SIBA and then the Lotus case. With respect to the provision under the chapter 6, if you look at the provision he cited the provision from the chapter 6 as well, and he argued that they are justiciable because of the presumption of justiciability, which Justice Latiba had alluded to in the Lotus case. The Attorney General disagreed and contended that the reliefs, that is the remedies, the declarations and other things which the plaintiff were seeking, did not raise any genuine issue of interpretation in terms of what have been canvassed in the jurisprudence already. Akusa, Sebwatin, Kov with Attorney General, and so on and so forth. So there were no constitutional provisions rely on which were unclear or ambiguous. So in Attorney General's view, the case had not met a threshold for invocation of the jurisdiction of the Supreme Court. And then the Attorney General also argued that government had already complied with constitutional duty by putting in place the necessary legislation. So he cited the fact that the government has enacted the Children's Act at 560, protecting various and compendium of rights of children, Criminal Offences Act at 29, protecting children from exploitation, and also Beggars and Destitutes Act, Act 392. So the Attorney General is saying that the government has actually done what is needful. And the problem was poor enforcement and not constitutional inconsistency. He also cited so many cases, including the Akusa case we know too well. Good. So the facts are just what we see from the arguments provided, whether the plaintiff properly invoked the Supreme Court's original jurisdiction, whether the reliefs are justiciable, and then whether the street children's condition violate Articles 28, 13, 15, and 35 of the Constitution, and whether the government is in breach of constitutional obligation regarding protection of children. Professor Mensah Bonsu authored the lay judgment of the court and held entirely that the plaintiff had failed to demonstrate constitutional inconsistency. In other words, the plaintiff had not met the threshold issue as whether there were interpretive issues. Are there provisions which are unclear, which are unambiguous, and so on? The court held further that enforcement lapses by statutory bodies do not raise constitutional interpretation issue. If certain bodies which have been given a role to play are not doing what is expected of them, that does not make it a constitutional issue. So the Supreme Court was of the view that its original jurisdiction cannot be invoked merely because government agencies fail in their duties. And then the court also did not find sufficient persuasion in the foreign cases of jurisprudence cited. So the case was actually dismissed. Justice Puaman who gave concurring opinion, supporting opinion, um, saw no sympathy with the plaintiff regarding the grievances, but then, and was also in agreement that yes, there's no doubt. If you look at Article 28 and other children's rights, they are all justiciable. But in his view, the plaintiff had used the wrong legal approach. Why is this so? Already in the lead judgment, the court has taken the view that we do not have interpretative issue, meaning that the threshold for invocation of Article 2 and 130 for interpretation and enforcement of the Constitution had not actually been satisfied. And for that matter, if you are saying that there have been violation of rights, we have a particular forum which the Constitution, in terms of Article 33, has earmarked as a venue for enforcement of fundamental human rights. So go to the High Court. Don't come to the Supreme Court. So the court held ultimately that it was absolutely misconception or wrong for the plaintiff to have sued the Attorney General directly in the Supreme Court. So these are just representative of the many cases you need to read and get yourself familiar with. So I'm going to draw the curtain down on this session. Then we are going to go into questions and answer segment. So if there are any things you want us to discuss, just let me know before I'll end.
No. No. Good
Yes.
morning.
Yeah. Good morning. Proceed.
Yes. Please, I want to find out, in the event that you are invoking the jurisdiction of the Supreme Court on interpretative issues, but on the other blind side of the plaintiff, you may not know that there is a human rights enforcement issue there. But when you go there and they find out that the issues of human rights enforcement issue, will you be sent back to the High Court to deal with it, or because you didn't plead it in your maybe in your summons, are they going to entertain such suit?
Okay, good. So, thanks for the question. Where a case is presented to Supreme Court under the guise of Article 2 and Article 130, and then it emerges that the entirety of the case is a human rights action, you need to go to the High Court. So the case will be dismissed, but the court will not make a direct referral. No. The court will not make a direct referral to the High Court. The only time courts make referral is appeal. Depending upon the type of appeal, the court can deal with it and say that this aspect of the case is remitted to the High Court to hear it and take the evidence. But if you go to Supreme Court for constitutional interpretation enforcement, and the court says that this case is not a case for constitutional interpretation enforcement, it's one of fundamental human rights enforcement, the court will not, although it has a power, but it will not do so because it will even be procedurally problematic. Where you are framing a case for fundamental human rights enforcement, there's a particular procedure. If we look at the CI 47 together with the Article 33, which you should follow, and the kind of information, evidence by way of affidavit which you put before the court is different when you are just going to the Supreme Court for interpretation and then enforcement issue. So you have to go back, and start all over. And again, where it happens that you presented the case for interpretation enforcement, and it appears to the Supreme Court that there's an aspect which is human rights enforcement. Unless the human right aspect is not just for enforcement for a particular person, but something like the if you like the latrine type of case, the nanam ampofoje type of case, or something like that. If it is enforcement for immediate benefit of a particular stakeholder, then you have to go to the High Court under Article 33. So that is it. Thank you.
Thank you, Doc.
Okay, in absence of further questions, have a good morning. We meet later in the day again. Victoria, yes, okay, no, just waving. Okay.